Welcome back to Client School, and today we're going to talk about parents that have, I should say ex-spouses and parents, who have to share the costs of their children's medical, health, and dental insurance and their uninsured medical, health, and dental expenses. Now, unless you have a unique decree of divorce, almost every divorce will have the parents sharing the costs of insurance for their children and the costs of their uninsured health and medical and dental care equally. So let's assume now that your child breaks his arm, and so you happen to be the parent that's there at the baseball game or something like that. So you rush the child to the hospital. The doctors are very kind and loving, and the nurses there and the doctors bandage the child, set the bone, put on the cast, and then hand you a bill for $1,000. You are the one that got the bill. You are the one that paid the bill. Now it's time for you to ask for your ex to reimburse you for half the cost, $500 in other words. What do you have to do under the Utah Code to get reimbursed? Can you simply send your ex a text message saying, Billy's cast cost $1,000, give me $500? The answer is yes, you can. But does your spouse have to send, your ex-spouse rather, have to send you $500? No, he or she does not have to do that. What do you have to do to ensure that you have a right to reimbursement? You have to provide written verification of the cost that was incurred and proof that you paid for that expense. You have to provide written verification of both. So now that brings us to the next question. Obviously, sending a text message isn't going to cut the mustard. But what if you get the bill from the doctor and scan that over and then email a copy to your ex? Is that enough to get reimbursed? No, because all that is a bill. Is a bill proof that you actually incurred the expense? No, it's not. And you can gripe and complain all you want to your ex about how it's like, this is a bill, you owe me $500. But the fact is your ex does not owe you $500 if you can't prove you actually paid the bill. Next question. So you've gotten the bill for the broken arm. You have paid for the doctor's bill, and you have what? Nothing to show for it? It's possible. Now can you get reimbursed because you've got the bill and you've written to your ex-spouse saying, I have gotten this bill, I've attached a copy to this email, and trust me, I paid it. Now do you get reimbursed? No, you do not. You have to provide written verification of the expense and written verification of having paid the expense. And how do you do that? With a receipt. You get a receipt from the hospital. You get a receipt from the doctor's office showing that it was paid. But not merely showing that it was paid, but that you paid it. What if some friend paid the bill? Does your ex owe you $500 even though you weren't out of pocket? That's actually an arguable question. I would submit that it's not. You don't get reimbursed unless you are actually out of pocket. To reimburse means to literally put more money back in the pocket or the purse. If you never went out of pocket, I don't see how you could be reimbursed by your spouse if a friendly neighbor or your grandma or grandpa paid for Billy's broken arm. However, there are some judges and some courts that inexplicably say that if you can show proof of the expense being paid and you make a request for reimbursement, your ex may have to pay that. If you happen to be that kind of ex, I wouldn't just whip out my checkbook or my credit card and pay this back. I would say, if you didn't pay it, X, I'm not reimbursing you because it's not an expense that you incurred. Other questions can arise, I should say, on the subject of reimbursement for medical and healthcare expenses. And if you have any questions, you know where to find us. But thanks for coming to Client School.